resolution was originally conceived, and nor is it the only tradition. And our first speaker today, Karen Drake, is going to advance our understanding of dispute resolution by explaining some of the features of Indigenous dispute resolution processes. So Karen, if you'd like to start, then please.
Great, thanks so much, Susan. So I'm just going to share my screen here. Okay, Ani Bojo, hello. Thank you very much to Susan Stewart for the invitation to be part of this panel. I'm speaking to you from Toronto, and I'm very grateful to live and work in the territory of the Mississaugas of the Credit First Nation, which is covered by the Dish with One Spoon Wampum. And I'm very grateful to each of you for this opportunity to engage with you today. So today what I want to talk about is using circles as a form of dispute resolution. And you'll see in my title screen here that I use the term talking circles. But different Indigenous communities might use different terms. So you might also see references to sharing circles or to council circles. Now I'm focusing on circles used as a means of resolving disputes, but talking circles can be used for other purposes as well. So just to mention, they can be used for decision making. So for instance, not when there's a dispute, but just some decision that has to be made. They're also often used in teaching. Now, Indigenous communities use talking circles within their own legal systems, but there are also examples where talking circles have been incorporated within the Canadian legal system. So just to mention a few, one is sentencing circles or criminal diversion processes. And for example, the Anishinaabe Nation Legal Services does this up in Thunder Bay, which is where I'm originally from. Another example is in the child welfare context. So for instance, the Gwinnett Council at Aboriginal Legal Services located in Toronto uses talking circles to resolve child welfare disputes. So talking circles can also be used as one aspect of a settlement of a civil litigation file. So for instance, when I was in practice, I had a file where the plaintiffs were individuals who were Indigenous and the defendant was an Indigenous organization. And they reached a settlement, which had a monetary component, of course. But as part of the settlement, the plaintiffs insisted that there be a talking circle between them and representatives from the defendant. And so that was written right into the minutes of settlement. So talking circles can also be used any time that mediation would be used, including, of course, in a labor or employment context. And there are many similarities between mediation and a talking circle, which is why I suggest this. But a key point of my presentation is going to be to highlight the differences as well. Okay, so that brings me to my goal in this presentation. I want to encourage anyone who is interested in using talking circles to do so. And my view is that it's not necessary to be Indigenous in order to use talking circles. So if we have all non-Indigenous parties, but they agree that talking circles would be suitable for their context or suitable for their particular dispute, and they have the necessary knowledge to fully implement the talking circle procedures, then my view is that they should absolutely go ahead and do that. Now, the key though, the point that I want to make here is that it's not enough to simply know the procedures for a talking circle and then to implement them. So later in the presentation, I'm going to talk about what these procedures actually are. Now, in and of themselves, the procedures are simple, right? They're very straightforward. Once I tell you what they are in about 5 or 10 minutes, then any of you will be able to go sit down and enact the form of a talking circle. But my thesis is that if all you know are what the procedures are, and even if you follow them all perfectly, you aren't really holding a talking circle unless you also know the worldview and the norms that inform those procedures, right? If you don't know that, then you're just going through the motions of a talking circle. So my goal then is to avoid what Aaron Mills refers to as constitutional capture, right? This notion that you end up reverting to your own worldview and that those norms and values then inform the procedures, even if the procedures reflect those of a talking circle. So in this presentation, I'm drawing from a paper I have forthcoming in the Federal Law Review, which is listed on the last slide in the references, just if you're interested. Now, I mentioned Aaron Mills. In that paper, I draw on his work. He's Anishinaabe, and he's an assistant professor at McGill's Faculty of Law, and he holds the Canada Research Chair in Indigenous Constitutionalism and Philosophy. Now, Mills posits a tree model of legality. And this model applies not just to Indigenous legal systems, but he uses it to conceptualize any legal system, including the Canadian legal system. So that's why we have two trees here. So one to represent the Canadian legal system, which Mills characterizes as being informed by liberalism, and another to represent an Anishinaabe legal system. And I'm talking about an Anishinaabe legal system in particular in order to avoid a pan-Indigenous approach. Right? So a pan-Indigenous approach assumes that all Indigenous peoples and their legal systems are a kind of homogeneous monolith, and that's inaccurate. So to avoid that, I'm just going to drill down and talk specifically about an Anishinaabe legal system. Now, in this model, Mills compares laws to leaves, but of course, leaves are not the entirety of a tree. And similarly, laws are not the entirety of a legal order. So to fully understand the leaves, we have to first understand the levels below. And we start with the roots. And the roots represent a society's worldview. A worldview includes its epistemology, ontology, cosmology. So what I'm going to do is a brief comparison of each of these levels, each of these aspects of the tree model, for both an Anishinaabe legal order and the Canadian one. And of course, due to constraints of time, they're going to seem reductive. So if you have questions afterwards, I want you to feel free to push back, to point out any reductive aspects of it. Now, starting with an Anishinaabe worldview. Here, the main premise is that creation is imbued with an inherent normative order. In other words, everything that we need to live a good life is given to us from a higher power. And we have a responsibility to identify, develop, and use the gifts that have been given to us. And these gifts include both sacred gifts, but they also include ordinary gifts, such as our knowledge, our skill, our labor, our material goods, and so on. Now, it also includes the premise that none of us has all of the gifts that we need in order to be self-sustaining. Right? So even if there is some billionaire out there who maybe has all of the material gifts they need to be self-sustaining, they don't have all of the spiritual, emotional, or intellectual gifts that they need to be self-sustaining just by themselves. So what this points towards is our radical interdependence with other persons. Now we can contrast this with the Canadian or liberal worldview. And again, if it seems reductive, feel free to push back against that. But here, the foundation is not what's unique to each of us, right? So it's not our unique gifts. Instead, the foundation of liberalism is a view about what is common to each of us. In other words, the inherent dignity of the individual person. So instead of having a responsibility to give our gifts, each individual is entitled to define, pursue, and revise their own conception of the good life. In other words, we're each entitled to delineate our own individual original instructions, as opposed to having to follow the original instructions of creation to give our gifts. What this highlights is the primacy of the individual, especially the autonomy of the individual. Now, moving up to the level of the trunk. The trunk represents a constitutional order. Now, when we hear the phrase constitutional order, we might initially think of founding documents and conventions. And those features represent one particular kind of constitutional order. But we can understand the concept of a constitutional order more broadly to refer to the way in which a people constitutes itself as a political society. So looking first at an Anishinaabe constitutional order, the logic here is the logic of mutual aid. And the conceptual architecture that informs mutual aid is that of gifts and needs. Here are the premises that we each have a responsibility, as mentioned, to identify, develop, and use our gifts in order to meet the needs of others. And this in turn entails responsibilities to identify the needs of others, as well as their gifts, and to communicate our own needs. Now, reciprocity within a mutual aid system is not necessarily direct reciprocity. So in other words, if A gives a gift to B, B does not have a responsibility or an obligation to give a gift right back to A. Instead, B can give their gift to C or D or E, who can then give their gift to Z, and so on and so on. And in a healthy mutual aid society, A's needs will eventually be met. Now, this raises the question of the limits of our responsibilities within these relationships, right? If we have responsibility to give our gifts, where does it end? How much of our gifts do we have to give? Who do we give them to? Maybe not just B needs our gifts, but C, D, E as well. The answer is that our responsibilities are bounded by our kinship relationships. So in other words, different kinship relationships delineate different responsibilities. Now, kinship relationships don't just refer to natural kinship. Kinship can be extended to those who are not actually related to each other as family. So for instance, a treaty relationship is a kinship relationship that has been extended between nations. Now, Anishinaabe constitutionalism is aimed towards harmony. Now, harmony is not a romanticized concept here. It doesn't mean an absence of conflict. There will always be conflict within society. But here, harmony refers to the operation of mutual aid. So it's the connection between community members who are freely giving their gifts and meeting the needs of others. Now, we can contrast this with the logic of a liberal constitutional order. Here, the logic is that of consent. And the normative architecture is not based on gifts and needs, it's based on rights and duties. And rights and duties are not cyclical the way that mutual aid is within the Anishinaabe constitutional order. Instead, rights and duties are binary, right? So if someone has a right, then there's some entity, either a person or the state, who has a duty that corresponds to that right. Their duty is to not violate that right. Now, the term duty is sometimes used interchangeably with the term responsibility or obligation, right? And so I talked about responsibilities within the Anishinaabe framework. And I think that this equivocation is what leads people to sometimes assume that you can take the logic and the legal architecture of rights and duties and impose them within an Anishinaabe system without doing any damage to the logic there. But I hope it's clear now that that's not the case, right? That rights and duties are specific to a liberal constitutional order, that they don't resonate within an Anishinaabe constitutional order, that to impose the concept of rights and duties within Anishinaabe constitutionalism is to distort that constitutional order, right? It results in misunderstandings and misconceptions. Okay, so returning to liberalism, the rights are held by and duties are owed to not only those within a kinship relationship, but also to strangers. Now, finally, within liberalism, the end goal is not harmony, but justice. Justice refers to rights being upheld and duties being fulfilled. Now we can move up to the level of the branches. And here we have our legal institutions and processes. So these are the set of procedures that institutions use to create, sustain, and unmake law. Now, starting first with the Canadian system. Law's force is external, insofar as the state exercises coercive authority over individuals. So laws are enforced through the state's legitimate exercise of force. For example, laws are imposed by the executive branch of government, such as police, a sheriff's office, or other mechanisms for enforcing legislation and court judgments. Now we can compare this to the Anishinaabe side. Here, law's force comes not from any external source, but from persuasive compliance. What this refers to is the practice of community members being persuaded to accept a given legal norm and to internalize it, right? To choose to follow it. So the force of law is not coercive. It's not external. Instead, the force of law is internal. Next, this brings us to the level of beliefs, in other words, law. So within the Canadian system, when law is imposed by an external force, such as the state, that entity needs some objective guidance about what that law is, so that it can apply it consistently to all individuals. And this is where rights come in. This is the function of rights. Rights delineate generalizable rules, and by doing so, they provide the certainty and the determinacy needed to apply these norms consistently to many individuals. We can contrast that with what happens at the level of beliefs within an Anishinaabe system. Here, the key term that's used within the Anishinaabe language is Anakanagewan. And Anakanagewan refers not to rules that are universalizable and generalizable to all people. Instead, it refers to an exercise of discretion or an exercise of judgment. And this is grounded in what happens below at the level of the trunk, right? So gifts and needs are not expressed as rights, and they're not expressed as rules. Instead, each community member practices the law by exercising their judgment about what their responsibilities are in any given relationship in light of what their gifts are and what the needs are of other parties in that relationship. Now, the key to this image is that each level shapes and constrains the one above it. So, for instance, the roots of a pine tree can only produce a pine trunk. Pine roots will never produce the trunk of a birch tree. Now, similarly, if you try to take a birch leaf off of a birch tree and paste it onto the pine tree, it's not going to work, right? It won't grow. So similarly, if you take Indigenous dispute resolution procedures at the level of the branches and try to apply them using the worldview, the logic, and the norms of a common law system, it won't work. The result is that those Indigenous procedures will be distorted and applied incorrectly. Okay, so now with that in mind, we can focus more specifically on the level of the branches, so on dispute resolution procedures. Now, I want to emphasize that my point here is not to compare a Western system with Indigenous systems for the sake of saying that one is better than the other. The point of the comparison is just to highlight the differences. So we're going to compare a model of adjudication, which would apply to arbitration, mediation, and then talking circles. So first, adjudication is adversarial. Right? So our civil procedure system and reflected in arbitration as well is a kind of formalized war. It's a contest between two or more parties to see whose rights will prevail. And just as in a war, there's a winner and a loser. So someone goes home disappointed. It's also hierarchical. So those who have legal experience are separated from those who don't, right? The judge is at the front of the room, elevated above everyone else. Now we can contrast this with mediation. Mediation, compared to adjudication, is not adversarial. It's thought to be cooperative. And this idea is emphasized by the notion of interests, right? So instead of focusing on rights, we focus on the interests of the party. And in doing so, the goal is to reach a win-win solution where everyone's interests are satisfied. So here there's no loser. But we know that the result in practice is often different. So a common saying is that you don't have a good settlement unless nobody is happy, right? So to reach a settlement, everyone has to give up something that they would rather not have given up. Okay, so let's look at a talking circle. Here, the procedures for a talking circle can vary depending on the community and the purpose of the circle. So the procedures I'm going to talk about are some common ones I'm familiar with given my research and my experience. Not every community will use all of these, and there may be others as well that I'm not mentioning here. Okay, so a key aspect of a talking circle is that there are no sides, right? So everyone is seated in the circle. So everyone, for instance, is included, and everyone is also seated at the same level. Now, to emphasize this notion of there not being sides in the circle, I can tell you a story about a circle that I held with an Ontario organization, and I had all the chairs set up in the room, and I was inviting everybody in to come and take a seat. And the head of the organization, so the chair and the other members of the head admin team, asked me, "Where's the front of the circle? So we'll all go sit there. We'll go sit at the front." And so I had to say, well, there is no front. It's a circle, right? There's no sides at all. There's no sides. There's no front. There's no back. Everyone's actually equal. It doesn't matter where you sit. You could sit anywhere in the circle, and it doesn't matter where any of your employees sit. That's the key point. So talking circles also include a range of participants. So not only those who would otherwise be in the position of plaintiff and defendant, or applicant and respondent, and so on. So it includes the parties directly affected, but also family members, community members, elders, anyone who could offer support in the circle. An object is passed around the circle, often more than once, and each person has an opportunity to speak when that object comes to you. When it's your turn to hold the object, then it's your turn to speak. And only the person who holds the object can speak. Let's say you're in the circle and someone has the object and they say something, and you think of an excellent point, and it's really only going to land if you make the point right as they're saying it. Too bad, you have to just hold it in your head and wait till the object comes to you. Participants in a circle are also encouraged to speak from the heart as opposed to through the filters of causes of action or defenses. Now, no one person or subset of persons in the circle is entitled to determine the resolution of the dispute. In other words, there's no judge or jury. Instead, everyone in the circle together is responsible for determining the root of the problem and how best to help those involved to heal. Now, each of these procedures is instantiated by the norms that we talked about, the level of the roots and the trunk. So the fact that everyone is included in the circle, not just the parties, reflects this notion that everyone is equal and radically interdependent, right? So we need everyone's gifts to be given and shared in order for the problem to be resolved. No branch of government is going to resolve the problem for you. Everyone who's in a relationship with the affected parties is equally responsible for helping to resolve the issue. Now, the goal is community healing, and this reflects what we talked about in terms of harmony, right? Finding a way for everyone to live together in healthy relationships. Now, the goal of community healing or harmony is not merely aspirational. The procedures used directly contribute to achieving this goal. So just to give one example, I talked about how the person who holds the object, whatever it is, sometimes it's a stick or some sacred item like an eagle feather, only they can speak. What that also entails is that they can speak for as long as they need, right? As long as they're holding it, no one else can speak. So they can speak and speak and speak, and no one can stop them. They can speak for as long as they need to. And we can see how different that is from our Western legal system, where parties are forced to speak through lawyers, and they're forced to speak through the architecture of the law, right? So through causes of action, through defenses. But also where factums and other submissions, including oral submissions, have strict page limits and strict time limits. Now, in contrast, what does it say when we say to someone, you can speak for as long as you need, and we will all sit here and listen? Well, that's a very powerful way to validate someone and their concerns, right? We're going to sit and listen for as long as it takes to everything that you have to say. And often that kind of validation is exactly what needs to happen in order to restore relationships. So to conclude, you can hold a mediation in a circle, but unless each and every participant in that circle is governing themselves in accordance with the principles of interdependence, mutual aid, and persuasive compliance, then you're just engaged in a mediation that happens to be set up in a circle pattern, right? If you're interested in truly applying the talking circle procedures, you can do that, but you need to learn the worldview and the constitutional order that underlies those procedures. And my view is that anyone who's interested can do that, can learn those things. All right, so miigwech, thank you. And if anyone's interested, the last slide has references.
Wonderful, Karen. Thank you so very much for that fascinating presentation. Certainly, it does make us think about the foundations of what we do, and was most interesting and inspirational. We are now going to hear from Chris Dassios. Go ahead, Chris.
Thanks, Susan. Karen gave you a very sort of broad-based comparison between different types of systems. I'm going to talk about one specifically, and you'll see that it is about as far as you can get from a talking circle. It's a very little talking circle. You don't get to talk unless the arbitrator lets you. And it serves a particular need. Talking circles actually, I think, serve many needs. My wife, who was a teacher for many years, told me that they were using it in her school where there were no Aboriginal people to very good effect. However, that's not the way we do business at the Power Workers Union, and I'm here to explain how. So I'll start with the general, and time permitting, I'll get down to the particular. The first thing to understand about a dispute resolution system is the obvious fact that it's a system. And the best way to understand and design a system is to realize that both the purpose and the structure are critical to getting the job done. In terms of purpose, that famous labor historian Friedrich Nietzsche said, to forget one's purpose is the commonest form of stupidity. And the purpose of any system is critical. In terms of a legal example, if you decided that the purpose of a tort system was to compensate victims of negligence, car accidents, and the rest of it, you would have a no-fault system, because that way everybody gets compensated. On the other hand, if you thought that the purpose of the tort system was to change people's behavior, the perpetrators, by punishing the bad behavior and rewarding the good behavior, you would have a completely fault-based system, because that's the way you ensure that the behaviors change. So the purpose dictates the structure. In terms of the structure, Aristotle said that men, because that's all that mattered back in the 4th century BC, and frankly, white men, to be specific, or Greek white men that are citizens of Athens, to be even more specific, Aristotle said that men acquire a particular quality by constantly acting in a particular way. Keep in mind, he said this 2,000 years before B.F. Skinner was born, but it is behavioral psychology. You change people's behavior, you change the incentives. The structure is built on incentives to change people's behavior, and that's the way you change the way that they think. So to give you an example of how I think this works, based on current events, the Black Death, which was not the current event I'm referring to, but the Black Death in the 14th century, in its first pass, the bubonic plague wiped out a third of the population of Europe from India to Iceland. By the end of the decade, half the population was dead. That resulted in the following legislative change on the part of the government of England, which was the Statute of Labourers, passed in 1351, which made it a crime to pay wages higher than the pre-plague wages and criminalized the refusal of the peasants to work. So half the working population had been wiped out. That leads to an upward pressure on wages because there was no manufacturing at the time. If it was a capitalist economy, of course, supply and demand would dictate that the wages go up. If it was a democracy, it wouldn't have ended up this way, but it was a feudal system. So the legal system there was run by the king for the benefit of the lords. They had the weapons. They could get the king out of power. The peasants couldn't. They tried, and this statute was one of the causes of the peasants' revolts. But the point is, in a feudal system, the result of calamitous death is to punish the people that survive. Fast forward to 2020, our plague, the pandemic, the result of that in a democratic age is trillions of dollars of support to people. That's the result of the fact that governments know that these people, killing off the electorate or letting them starve is not good policy when you're living in a democracy. It doesn't matter in a feudal system. So my point is that the structure dictates the results in that context. And if you doubt that, don't believe me, believe Amartya Sen, the Nobel Prize winning economist, who points out that there's never been a significant famine in a functioning democracy. And you sort of say, well, why is that? The reason is that famine is almost never the result of a complete shortage of food. It's a result of resource allocation. So there may be a shortage of food in one place, but if a government is motivated, they will fix it. So the two biggest famines in the 20th century were both in totalitarian regimes, of course, Stalinist Soviet Union and Maoist China. In India, famines were endemic when the structure, the government, wasn't democratic, when the British were ruling the place. The famines disappeared as soon as the British left behind a functioning democracy, because suddenly, again, killing off the electorate that can throw you out of power, not good policy. But I digress a bit. Let's bring it back to arbitration. Looking at arbitration, the purpose is not for the parties. The purpose is not to add case law to the books. That's what economists call a positive externality. The case law helps other people, but not the people that are actually paying for the arbitration. What we need is a bottom line decision and a couple of pages explaining how you got there. The rest of it is for the benefit of others. Purpose is not to uphold natural justice as far as the parties are concerned, or to cross-examine witnesses, or to do things that lawyers love to do. The purpose is actually to drive accountability for disputes down to those responsible for disputes and those who can settle the disputes in the workplace, on the plant floor, as we used to say. It's to discourage unnecessary disputes and to resolve necessary disputes quickly. The problem with the structure of the traditional arbitration system, which when it was first invented back in the 50s, there were systems whereby a union person and a management person could phone an arbitrator from the plant floor, according to Harry Arthurs, and get a decision over the phone. That's the way it began. It devolved into cases that were being heard typically by judges back then, but resulting in short decisions, and then it became bloated and calcified. It became what we call the traditional system, which gave lawyers free rein to treat every dispute as if it were a federal case, with the full panoply of natural justice, cross-examination of witnesses, et cetera, et cetera. And we'd all seen this movie before. The common law courts in England had started off as a dispute resolution mechanism that had become so calcified and so procedure-laden that the king set up the courts of chancery, which were intended to be equity courts to get to the bottom line and do justice rather than fall into the procedural traps. Well, if you read Bleak House, you know what Charles Dickens referred to the chancery courts as, literally on the first page of the book, I think, which is the most pestilent of hoary old sinners. I'll say it again, most pestilent of hoary old sinners. Nobody wants to be that, and yet those courts fell into it. They got worse than the common law courts. And so the arbitration system went from a good idea in the first place to something that became the thing that was despised in the first place, and it was invented to get away from. Anyway, so we end up in a system traditionally where days can be spent on preliminary objections. It's like the lawyer, and whether it's management or union side, the night before the hearing finally looks at the file and realizes, holy crap, if the arbitrator figures out what actually happened here, my client's screwed. And then they go into the obfuscation room where there are shelves, dusty, hoary old shelves, full of preliminary objections you can use. Timeliness, mootness, rightness, the collateral evidence rule, the hearsay rule, and on and on and on it goes. To get away from the truth being discovered by the arbitrator. That's not the purpose of the system. As one English judge described a courtroom full of the law of evidence, it's deathly dark and smells of cheese. These rules that were ostensibly developed to help adjudicators get to the truth become enemies of the truth. And so that's what we wanted to get away from in 1998 at Ontario Hydro. The Power Workers Union represents about 3/4 of the workers in the electricity industry and the industrial end of the electricity industry in Ontario. And hydro at the time was the biggest utility in Canada by far, I think. At its height, the PW bargaining unit alone was 21,000 employees, but by packaging people, it had gotten down to about 14,000 at its low point. The system at the time, in 1998, there was the full-blown 3-person panel system that led to a typical arbitration taking 6 days of hearing to dispose of, spread out over a year. The hearings would take place typically between 10 a.m., except for one arbitrator who always dropped his kid off at hockey. We started at 10:20, and end around 4:30, with an hour and a half lunch in there and a morning and an afternoon break. And 3-person panels, making scheduling that much complicated. It had fallen into what Sir Edward Gibbon would call supine indolence. Things were not moving quickly, and it was expensive. The simplest of grievances taking 6 days, think of the cost. So in 1998, we had to figure out how to fix it. And there was, and this is absolutely necessary, of course, there was the will on the part of both parties to fix the system, both the employer and the union. Now, the employer, one could argue, was doing it for purposes that didn't really have to do with labor relations, in the sense that the Harris government had decided it was going to break up Ontario Hydro and sell it off. And of course, the sale price turns on how many grievances you have backlogged. We started with 3,000 grievances backlogged in the fall of 1998. We implemented an expedited arbitration system with a really expedited backlog clearance. We were down to 500 grievances by the spring within 6 months. And so it may have been that motivating the employer, but whatever. We looked at the purpose of the system and built a structure to get to that purpose. The purpose of arbitration, again, is to get justice quickly. Labor relations justice delayed is labor relations justice denied, is the old saying, but we were prepared to live by that. So the structure that was created was a mechanism to ensure that dispute resolutions occur by default. That is, we went from 3 steps in a grievance process that required some party to take action to get to the next step, to a system that consisted of 1 step, and if nobody took any action, the case automatically went to arbitration or mediation. So the incentives were there. The default was that you would get the thing resolved. Secondly, a mechanism to hold accountable those responsible for filing the grievances and resolving them on the plant floor, which was the 1 step in the grievance process, was a grievance review board, which is a 4-person panel consisting of 2 union and 2 management people that sit there, and each party presents the grievance to them. And by consensus, they decide to either resolve it, dismiss it, or by default, it goes to mediation or arbitration. And that made the parties responsible for driving sensibility in the workplace. And the nature of these things is many cases are presented in a single day, and so you trade them off. Union's got a bad grievance here. It says, I'll drop it if you give me something on that grievance over there. Then it seems to work, because it only works on a consensus basis, of course. So it's not as if you can sort of inflict a decision on the other side, but it forces people to work together in a consensus manner. It would be a talking circle, except there's not that much talking. Thirdly, we needed a mechanism to resolve all procedural issues. The end of the obfuscation room. The resolution of procedural issues, including scheduling, production of documents, preliminary objections, before any hearing begins. So there's a chief arbitrator, which is critical to the system, because that person is seized of all issues in all cases until it gets assigned to a specific arbitrator, and deals with them by phone, typically. So you got a preliminary objection, it can be dealt with in a matter of minutes, and it doesn't slow down the hearing process. And fourthly, the hearing process is designed to dispose of multiple cases in a day. So there is full disclosure by each side at the GRB, at the one grievance step prior to then. Each side has to tell the other what they've got in terms of documents, what their position is, what their evidence is. We went from a system where, you know, the parties would do the dance of the seven veils and not really begin until just before the hearings, into one where you're required to open your kimono before the GRB and show the other side what you got. And that speeds things up. When you get to a hearing, these hearings are done almost always on the basis of briefs and no oral evidence. And some people sort of figure, oh, how's that? Well, as it turns out, there are very few relevant facts and disputes in most of these cases. And remember, this is a high volume business. There are lots of facts in dispute. Very few of them are actually material to anything, certainly not material to the arbitrator. And so once each side files a brief, often it's the case that if there's any relevant fact in dispute, the arbitrator can just ask the question in the hearing room as the presentation is being made without swearing in a witness or anything like that, let alone, you know, examination in chief and cross-examination. And if you find it hard to believe that, let me tell you this. So this was under the old system, and the hearings at that time were done on the same floor where my office is in the PW building, and there was a very reputable arbitrator conducting this case. It went on forever, just days after days. At some point, he gets tired of, he or she, they get tired of carrying the 7 binders of evidence that has been filed, I think, by the union back and forth, and says, Chris, you know, do you mind if I leave these on the top shelf of your thing here? And I said, fine, leave them, and you pick them up the next time you're doing the hearing. And a couple of months later, a decision comes in, and I read it. It's a very well, long thought out, logical decision in the case. And I look up, and there's the 7 binders still on my shelf. 7 binders of evidence, not one bit of it mattered to the decision. And the decision was right. But I say that even though the grievance was dismissed, the decision made perfect sense. But this is what people do. They shovel in this stuff that doesn't matter to the arbitrator. It must drive the arbitrators crazy. I'm not asking for any comment, but you can get these things done on briefs, and we almost always do. If it isn't resolved, at some employers we do mediations. There are rare cases where you do really need something like a full-blown hearing because it's a termination, there's a lot at stake, and somebody's lying. Either the griever's lying or the manager's lying. And with that kind of credibility issue in place, it's frankly even hard to do a Zoom hearing. We've had to do some in-person hearings during the pandemic in cases like that because the arbitrator believes that they need to see the people in the room. But even in those cases, we almost never allow evidence to be called in chief. Each party files will-say statements, we call them, which is the evidence in chief of the witness. So there's no evidence in chief called. The other side just gets to cross-examine them, and there's a re-examine on you go. And even that has shortened the process. It is extremely rare for even a full-blown case to take more than a day or two. And that just works better for everybody, frankly. You know, so now we're getting at least 2 cases disposed of in a day instead of 1 over the course of 6 days, which is a mere 1,200% increase in efficiency. That alone is like gigantic benefit to the parties. The system is front-end loaded, costs real money because everybody has to do the work, real resources, because everybody has to do the work up front. But the resources expended per case have gone down dramatically. And these things are dealt with in a fraction of the time that they used to be. And what became evident, because you know, I entered the thing with a bit of trepidation. Our members were used to the full-blown hearing, and there's some satisfaction, even if you know you're going to lose the grievance, to see your manager that you hate cross-examined mercilessly by a union lawyer. There's some satisfaction in that. It's undeniable, just as there is for a manager to see, I've got 8 minutes left, 3 minutes left, according to mine, but I'm almost done, Susan. As there is some satisfaction for the manager who didn't select this individual because they are useless. However, on paper, in a seniority-based selection, they had to be selected. There's some satisfaction for that manager to see that witness mercilessly cross-examined by a management lawyer, but it's a price too high to pay. So what we learned is that, you know, people that were used to a Cadillac system are quite happy with a VW Beetle. They get an answer quickly. Anyway, to wrap up, to Aristotle's point about changing people's behavior, once they realize that once a grievance is filed, you can run, but you can't hide from the result, things get resolved more quickly. To Nietzsche's point, we're sticking to the purpose of the system, which is to drive accountability down and to get justice in the workplace quickly. Structures have had to adapt as the company was split up in different places, but structures always end up having to adapt in the real world because we're always in a state of flux, just like this conference had to adapt from an in-person session into a Zoom session. I think the message is still getting across, although I prefer the in-person stuff myself. Thanks for your patience.
Thank you very much, Chris. It's always a treat to hear from you. And of course, when Chris speaks, you don't get to hear just about dispute resolution systems. You get to hear about the Black Death and Aristotle and many other things, but always interesting, entertaining, and Chris, we're grateful for your contribution. So now we're going to hear from Chris Albertyn, and I think Chris is possibly going to defend arbitrators a little bit. I hope so, if there is a defense to be had. So Chris, go ahead and tell us about the evolution of dispute resolution in Ontario and where we are now.
Okay, thank you, Susan. I'm going to talk about developments in arbitration in Ontario, covering much of the period that Chris has just described, but from really the mid-90s till now. And there's been quite a significant change in a number of areas, and I thought to focus around 4 particular areas. The first is to talk about the Med-Arb and the development of the Med-Arb as a mix of mediation and arbitration as a significant part of the work now, in a way that as it wasn't back then. Secondly, and related to that, is the procedures for expediting the hearing, some of which Chris mentioned, but those have become more generalized throughout the system. Thirdly, to talk briefly about individual restoration, which has become much more a feature of arbitration than it ever was. And then lastly, briefly on some collective restoration. So on the first, the Med-Arb, I think as a result of cost chiefly, and as a result of a desire to end these long hearings that Chris described, where there's just a result, where there's a finding and everyone's got to live with it. There's been more of a forward-looking focus towards outcomes. What's the ideal outcome for this, this particular case, rather than looking back on who's to blame or obviously one needs to understand what went wrong, but the focus away from blaming particular individuals and making findings of fault towards what's the solution? What are we going to do with this? If it's a termination case, is the person coming back to work or are they leaving? And if they're leaving, what kind of money are they going to accept, as an example? If there's a collective issue, what is the solution that both parties can live with? So the idea of exploring solutions has become very much a part of the arbitration process, and many arbitrators now in Ontario will spend their first time with counsel particularly, but also maybe more broadly with the parties, talking about how should this end, rather than about who's right and who's wrong. Then if there's no resolution, the process of deciding how to continue with the case has also been expedited, in the sense that, as Chris mentions, God, I suddenly get a string of phone calls coming in now, sorry. As Chris mentioned, oh, I've lost my train of thought momentarily. You've reached a point where you haven't reached a settlement, but you've got a pretty good idea of what the parties' differences are and what the dispute is about. And to Chris's point, the differences of fact are not that critical really on the main points. So the parties will very often agree then to do a will say statement rather than having evidence in chief. That's convenient because if there's going to be any cross-examination, that can happen pretty easily. Or there's almost an agreement of, these are the limited issues in dispute, and we'll hear some evidence on that, and then there'll be a decision on it. But the MED-ARB process continues right through it, so that if the evidence reveals something that wasn't really apparent afterwards, it's quite possible for the arbitrator at that stage to re-invoke the idea of, let's try and see if we can settle this. Let's have a discussion in light of what we now know. And isn't this a better solution to the outcome? And thirdly, on the individual restoration, the nature of the cases has changed a lot. A lot of our cases now deal with accommodation claims, claims by individuals that they're not being treated properly, claims by individuals to have been harassed, to have been discriminated against. And a lot of the focus of that is similar to what Karen was talking about, is the need for dealing with the harm that people have felt, dealing with restoring them and validating the individuals who are complaining. So that involves a different process, and we've, as arbitrators, have got to be open to ideas of allowing, I mean, Karen gave the example of allowing somebody to just talk and talk and talk to explain their feelings about an issue, but allowing much more of that kind of healing experience for individuals within our framework, which is a labor arbitration dispute, allowing people to feel that they've been vindicated in some way and to try and address the issues that they feel comfortable to go back to work and to work with the people that they work with. And that leads into the discussion of the collective restoration, very similar to the kinds of points that Karen was making, which is, how do you involve often the people who are the leadership in the organization, the leadership of the management, the leadership of the union, are not the people who are setting the culture in the workplace. The culture is often dictated by influential groups, often bully groups, who kind of control what goes on the management side, lower management, and on the worker side, not necessarily in the union shop steward representatives, but among just a bunch of bullies run the show there. And there's a need to change that culture. And so what happens and how it manifests is lots of complaints of not being heard, complaints of management never listening to us, complaints of management, you can never trust the union. Those sorts of poisoned work environment explanations are often the catalyst for realizing there's a culture that's noxious in this workplace. There's a culture that's not working well that needs to be altered. And the sorts of ideas that Karen was speaking about, circles, addressing it as equals, allowing everyone to talk, expatiating on the experience, all of that is valuable as an area that arbitrators have to deal with, and also have to think of ways in which one doesn't end those processes with just, we're all going to be nicer to each other, we're going to treat everyone with respect, we're going to stop being nasty to each other. There's got to be more detailed commitments in those areas. So there's a mix of a legal feature to it, of what's the kind of civility agreement that parties are going to live with. How does the civility agreement marry itself with the collective agreement? And what's the accountability? What if people don't comply? And who's going to be supervising the application of those agreements? So that's just to say that the areas of just going into a hearing and sitting down and listening to evidence and making a decision, while that still exists, the field has changed a lot towards, I think, more solution-orientated outcomes. Thanks, Susan.
Thank you very much, Chris. Interesting session, and thank you for tying together the comments of Karen and of Chris Dassios. We are now going to hear from Jasbir Parmar, our fourth and final speaker today, and then there'll be an opportunity for questions. Jasbir, as I indicated, is going to talk a little bit about the interest arbitration process. Go ahead, Jasbir.
Thank you, Susan. I'm at a bit of a loss. I found the other speaker so entertaining that I kind of forgot the things that I wanted to talk about. So just give me a minute. We'll just look at my notes. So I'm going to be, my comments are intended to be a complement to those of my colleague Chris, who's spoken about the rights arbitration work that we do as arbitrators in Ontario. I'm going to be speaking about interest arbitration in terms of arbitrators coming in and determining the wages and working conditions of the parties. I'm going to be speaking primarily about Ontario, but largely in Canada, it's mostly done in a similar fashion. While it's not without its problems, as critics on both sides of the table will tell you, in my view, when interest arbitration is examined in a broader context, one sees that the Ontario process is generally well received as a positive process to resolve labor relations disputes. And I note that this is, despite the critiques, I would say that this is evidenced by, just within the last few years, by specific examples of parties who are not actually governed by a compulsory interest arbitration scheme, and yet have turned to interest arbitration to resolve their issues. I think of one example just in the last couple of years, which was in the post-secondary education sector, where there was negotiations of one collective agreement at issue, but it was a collective agreement that affected more than 10,000 employees, and it disrupted the education of some 500,000 students. And so while the union went on strike, it was after a lengthy period of time, the government intervened at really the behest of the employer. The employer wanted binding arbitration. Another example is the doctors in Ontario negotiating with the provincial government with respect to their fees in the public healthcare system. And so this is an area where the doctors aren't even in an employee-employer relationship as we typically understand it. And it was the doctors who lobbied for binding interest arbitration. And so in my view, the fact that these parties who are in a place where they can actually exert other methods of pressure in order to achieve their results, which in our, as Karen indicated, you know, in our liberal structure of individualism, where we want to be able to carry our rights forward and fight the good fight, and yet the parties that don't have to do that still look at the interest arbitration process and think it's a good process. And so I'm just going to speak to three components that I think are the elements of the Ontario process which make it a favorable process. First, it's the element of neutrality. And when I speak of this, I'm referring not just to the traditional definition of neutrality, as in that there should be a lack of bias, but also to the concept of neutrality that flows from expertise. In Ontario, the arbitrator community is comprised of individuals who have extensive experience either as labor relations practitioners or as experienced adjudicators in labor relations. Moreover, the parties generally choose the arbitrators themselves. And so these individuals are true neutrals in that they're all private practitioners. And this is particularly important given that most interest arbitration is done as compulsory arbitration and occurs in Ontario in the broader public sector, areas such as health. Given that there's an awareness of the existence of a relationship between a broader public sector employer and the government, it's critical that the government not be seen as having a hand in selecting the arbitrator. Now, of course, the idea of a consensual process only works if there is a mechanism to deal with the situations where consent is not achieved. And so the governing legislation provides for a method where the minister can appoint an arbitrator in that event. But what's critical is that even in that case, the principles of general acceptance are still maintained. And the minister appoints generally by referring to a list comprised after consultation with the labor relations parties, who are able to indicate to the minister who is generally acceptable. And the importance of this element in the broader scheme of interest arbitration being an alternative dispute resolution to a system to the right to strike was underscored in Ontario in the late 1990s. At that time, the minister decided that rather than appoint people from the list, he was going to appoint retired judges to serve as arbitrators. Now, in many respects, that wasn't such a crazy idea. As Chris Dassios indicated, judges had been involved in labor relations for many years in different ways. But nonetheless, the action was challenged, not the specific appointments of the specific judges, but rather the minister's actions. And it was challenged by the unions, and it went all the way to the Supreme Court of Canada. And now you can imagine the idea of impugning the neutrality of judges, the idea that they are somehow biased was obviously a non-starter. And yet the court held that the minister was required to exercise his discretion in a manner which accorded with the purpose of the legislation. And that given that compulsory arbitration was supposed to serve as a substitute for the right to strike, which was being denied to these parties, the court stated that the arbitration process had to be seen by the parties not only as neutral, but also as credible. And they recognized that the hallmark of an effective process for labor relations was that it was grounded in a consensual process. And therefore, in order for the appointments to be reasonable and a true alternative to the right to strike, the individual arbitrator needed to not only be neutral in the sense of being bias-free, but they also needed to bring labor relations expertise and to be recognized by the community as having that expertise and neutrality. The second element of the Ontario process is that it serves as an extension of bargaining. And so one of the criticisms of compulsory interest arbitration is that it can serve to have a narcotic effect on the parties by failing to sufficiently encourage them to engage in the difficult exercise of surrendering certain goals in the interest of achieving a resolution. And just like Chris was commenting about how arbitrators have dealt with it in rights arbitration in Ontario, they have responded to this challenge in interest arbitration by fully embracing the MedArb process. And so it's quite unusual for an interest arbitrator to not show up and attempt mediation, even when they've been appointed to serve as an arbitrator. And in many ways, their ability to do that intersects with the concept that I was just referring to, which was their general acceptance in the community as being neutral, as being experts, and being bias-free, so that when they're engaging in that process, they're still able to maintain that role. In Ontario, the individuals that conduct interest arbitrations are part of the same community of individuals that conduct the rights arbitration. And so they're seen as having a thorough understanding of the problems that the parties face during the life of the collective agreement, which is seen as critical to their ability to properly craft a collective agreement which works for the parties on a go-forward basis to help them in avoiding those problems in the future. And so this expertise assists the individuals who are the arbitrators in achieving a trust relationship with the parties, and so that they're able to be effective in helping them negotiate a resolution. Even when they're not able to actually achieve the negotiated resolution on its face, I do note that the very presence and involvement of the arbitrators actually often assists the parties in reaching an agreement. And that's because the parties, there is undoubtedly a political process that's involved in collective bargaining. You have to, rally the troops to come and fight for your issues. And sometimes that rallying process makes it difficult for some people to let go. Even though the parties recognize that they're not able to win on all their issues. And so in this mediation process, they're often able to identify to the arbitrator what their priorities are in a way that they simply cannot do in a formal litigation process. And so arbitrators are often, at the end of the day, able to issue a decision, which looks like a decision, but really it's something that both parties have indicated is actually an acceptable solution. And I actually think, you know, sometimes that's viewed as a critique in terms of Dassios' comments about accountability. But I think because there's a larger political component, this is actually a good method to kind of deal with some issues in that regard. And the last element that I want to talk about is the efficiency of the process in Ontario. And and the reason I want to talk about that is because the reality is that while the collective bargaining process is going on, while the parties are engaged in that process and until they reach a collective agreement, the reality is there's an animosity between the parties, and that drifts into the workplace and it reveals itself through other conflict. And so until this is resolved, you're going to deal with conflict somewhere else down the line. And so, unfortunately, in Ontario, there is some delay, but the delay is largely in respect of scheduling the arbitration. And that's because, unfortunately, there's only a small community of people that the parties seem to be prepared to appoint. So it would be great if we could broaden that. But once you get to that arbitration day, the arbitration itself is conducted usually in less than 1 day, often a half day. And that's because, except for the very rare cases, there is no viva voce evidence-led. We operate on a scheme of written briefs. And because the reality is there isn't really room for a lot of disagreement on the facts. There's a lot of room for disagreement on what should be taken from the facts and what the results should be flowing from those facts, but not really about the facts themselves. And therefore, the oral presentations are focused on highlighting the key issues that are in dispute with a focus on what the statutory principles are that we're supposed to be looking at to achieve the outcome, principles such as replication and the proper comparators. And one other component of that, I would say, to our process that makes that possible, that efficient process, is that it's a tripartite process where each party is able to have a nominee to the arbitration board. And so they feel that there's someone who is informed of their issues and able to speak to those concerns during the decision-making process off the briefs themselves. So just in closing, I just want to note, I've sort of carved these out as different elements, but you've probably noted that they all really speak to two basic principles. Those are the principles of legitimacy and trust. And so we've created a process that the parties see as a legitimate process with people involved in it that they feel they can trust. And I think that because of those two principles, they feel like, you know, whatever they might complain about what the actual specific outcome might be, that overall it's a process that works as a true alternative to the right to strike. So those are my comments.
Thank you, Jasbir. Thank you very much for your interesting comments about the interest arbitration process. So I don't see any questions that have been raised on chat. But I'm going to ask a question because I'm the chair, and certainly people can chime in, but any panelist can respond to this. Our topic today, of course, is innovation, and we've talked about certain developments, and we've had the insights from Karen as to the foundations of our system and some interesting comparisons in terms of what we think is novel, mediation. And your presentation, Karen, has really, in my mind, allowed me to think a little more creatively, hopefully, about some of the foundations of what we think is innovative. But I just wonder if any of the panelists could comment on, what do you think the new frontiers are? Talked about, as I said, some things in the past. In particular, does the innovation in terms of technology that we're experiencing today and that we've all been experiencing generally with respect to video conferencing, is that a possible step forward, or is it problematic in terms of labor relations? Chris, Dassios, I think that you suggested that you have greater comfort with in-person hearings. Maybe you want to start off on this.
Sure. Can you hear me?
Yes.
Yeah. Okay. As the pandemic hit, the first response from, at least with the employers that I deal with, was to sort of put off because you had no idea how long this was going to go on, was to put off the cases that didn't need immediate resolution and to deal strictly with the ones that did. And we did that generally via Zoom. A couple of the employers, and you have to realize that the IT security issues, particularly for generators in the electricity industry, are sort of at a heightened level of both scrutiny by regulators, but also paranoia on the part of the companies, because hacking into the power grid is something that that would be a very effective means of destabilizing a society. And so they were very reticent to use Zoom at all, because there were, media stories about how people were hacking in with porn into Zoom meetings. I mean, and that would be a real problem in a hearing, of course. But you never know, and this is the nature of the media in a world where the media is much more variegated than it used to be. It may have been Zoom's competitors sort of putting out those stories. And always with technology, it may be an issue with the software, or it may be an issue with, as IT people call it, a user issue, which means whoever's using the software doesn't got the settings right. In any way, they came to Zoom, and Zoom did sort of improve its security measures. In any event, they've now become comfortable with it. Early on, I ended up doing like a 15-hour mediation on Zoom. The benefit of that is I was at home. It was a Saturday, and about hour sort of 10, I realized I knew where the deal was going to be, and the rest of them had to sort of get there, so I could sort of grab a drink. Just come on, you guys finish up. I'm waiting. But it's a lot more comfortable than being in a hearing room and going out and getting the stale peanuts or whatever you got. So it's actually become very useful. I suspect it is going to become a permanent part of the system, because it is a lot cheaper to do it that way than for us, because the hearings take place in Toronto generally. The members, the managers, and the grievers are spread out all over the province. There's a real cost to bringing people to Toronto. Now, the grievers, and I suspect this is true of the managers, quite often quite pleased to come to Toronto and get away from wherever they are, spend a night at a hotel, and go to a shishi bar or whatever they do when they're here. I don't know what they do. But there is a cost to it that could be reduced dramatically. And so I suspect the system is going to be in place permanently for some cases. For others, not so much. And again, my preference is to do it personally, but you have to weigh the cost of that. And so there are some grievances that I think will be dealt with remotely regardless. And the mediation I was dealing with, there were a couple of them. They were important cases, and they were done quite effectively over Zoom. It wasn't a credibility issue because it was a mediation, but it can work.
Thank you, Chris. Chris Albertyn, I think you wanted
I'll
to
just speak briefly on, I've had a few experiences where we've actually had witnesses using Zoom, and very much depends on the equipment you've got. If you've got a nice big screen where you can watch the witness and you're taking notes separately and you're looking at documents separately on some other tablet or computer or laptop. And the key thing we found was that in this particular case that I'm describing was to have the witness pin the counsel. You can pin the speaker. And that established the kind of interaction between counsel and the witness that is valuable for counsel. And the problem is if the witness is looking at counsel asking questions in the gallery view, seeing everyone equally as a tiny figure, that's not much use. And also, the other thing we did was we had all the cameras turned off of anybody but the counsel and the witness and the arbitrator. So it meant when the witness had counsel as a big picture in front of them, that actually established the normal interaction you would have in a hearing room between the witness and counsel. And from my perspective, I mean, I had the witness, a huge big image of the witness actually better than in a hearing room. Now I know there are potential problems, people may cheat and that sort of thing, but most witnesses don't cheat and seldom do you have interference by people but you can take some precautions on that too. So I think there is more scope for it. And I think also the other thing is we've typically operated on the basis of a day. You book a day to do a case. And I think there's more flexibility now with this. You could have, you're dealing with preliminary issues on one case in the morning, you're dealing with, I mean, I think it opens up new possibilities of how we conduct our practice, I think.
Thank you, Chris. There are a few questions now on chat. One I seem to have lost. It was Annalise Kruger. And the question was to Chris, if you could briefly describe the process that took place in terms of your collective agreement bargaining partners to get to the protocol that you did develop. Just in a few sentences, you could explain that to us.
Yeah, that was actually a mediated collective agreement. So Martin Duplitsky was the mediator, and he and I and John Murray, who at the time was counsel to Ontario Hydro, just sat in a room and came up with this process, is the short answer.
Thank you, Chris. And then there's a question, and on my chat, I don't see the name of the person who asked the question, but it is essentially, the question is how parties can move away from being dependent on a third party in order to resolve their issues. Now, we arbitrators don't recommend that because you know, we like people to use our services. But if I could respond briefly to this, is something I think about in my capacity as chair of the Crown Employers Grievance Settlement Board. We do a lot of mediation there. About 85% of our cases are resolved through mediation. And I see the evolution there, which came from a strict adjudication model to a mediation model. I see the next stage, the next innovation of the parties really learning the lessons from the mediators that they experience on a day-to-day basis. What we do is really that kind of thing that that Karen, Chris, and Jasbir have described, and that is that we listen to people, we listen carefully to what the issues are, and we assist them in by asking questions, by exploring the issues, to come to an understanding of the other side's position and where a fair solution might be, or a solution that will allow them to move on. So, you know, I think that in short, that is the answer to that question. You know, our services continue to be expensive to the parties. The process is costly, not just in terms of time, but in terms of emotions. The mediation process, we hope, is less so, less adversarial, but certainly the lessons that that we teach in the mediations that we do are certainly lessons that parties can learn and can apply themselves. And Chris talked a bit about the joint review process that is utilized under his system. And, you know, that's an example of that. People who will do a neutral assessment of the case, the likely outcome, they'll engage in consideration of the interests, the concerns, and they will get to the solution. So I hope I haven't done us all out of business, but I also hope that I've answered that very important question. And I see the next question is from Shannon Porter. The question is whether people can comment on the voice of rank and file in these processes. And there was reference to trading off grievances, the reference to the low rate of DFR success. But essentially the question is how well rank and file are included and how much voice they effectively have. So any of our panelists want to comment on that?
Can I, Susan, comment on Patricia's question that you answered already? But, you know, the thing about most arbitrators tend to work with the same groups of parties that they get familiar with, and they get to trust each other and work well with each other. So it is true that there's some parties change around and they use all different arbitrators, especially for one-off cases. But the most success of the role of an arbitrator is where they have regular relationships with the parties and know the parties and come to know the collective agreement and the issues that arise. So the parties have a lot of choice over that. If they get if one side gets uncomfortable with a particular arbitrator, they can try somebody else. They just don't need to agree. So, I mean, that's the. And there's also a lot of younger arbitrators coming up that, you know, parties are encouraged to try that as an alternative to those that they've had experience of before. On Shannon's point, I mean, I think you're dealing really with the interest arbitration side there. And you're always dealing with a bargaining committee to start with. And so in those mediations, there's a bargaining committee as part of the union group. You're not just talking to counsel. So there's sort of three levels you're talking. There's the bargaining committee, who are representative of the workers, often very much the activists within the local or within the workplace. And then you've got their counsel, and then you've got the union nominee, and then the equivalent on the management side. So when you're striking a deal, and as Jasbir was describing, and you're trying to work out a deal, you are actually very conscious of, will this be acceptable in the workplace? Will this be a good result? And I think, I mean, the benefit from their point of view, if you look at the sort of level of inflation and the level of increases, if you strike for 1 week, that's 0.5% of your annual earnings is gone. So people are, you know, to go on a strike, which is going to be effective at any level, when the average wage increases are in the sort of 2% range, 2.3% range, and there's a fight around that, you know, to strike over that is a big impact on you for a long-term gain. And typically you're not getting a long agreements out of it anyway. So I think in my experience, unions are very conscious of how is this agreement going to be seen among the workers, that there's not the sense of we're just going to impose anything on them and it's not going to be, you know, and they got to live with it. I don't get that sense at all. They want to be able to report back, we've had a success, we've done well in this collective agreement.
Thank you, Chris. Now we're just about out of time. Any other panelists have any comments before we conclude? And I don't see any other pressing questions. So I would like to thank our panelists. It was an excellent, thoughtful presentation from all of you, deeply appreciated. And for everyone's information, I understand that this presentation will be available on the website so that you will be able to go back and see it if you wish, or let your colleagues know about it. So again, thank you very much to our panelists. Thank you to our audience members for joining us. And we are now going to conclude. So goodbye, everyone.
Susan. Thank you.
Thanks.